himself.
I'm a kind and loving father. That's just what I am. I'm very kind and gentle. And I don't ever willingly harm anybody.
This time he's in court defending himself against charges related to that trailer filled with women and girls. This is a wild story of a wild trial involving an evil man representing himself in court and facing his wives in trial.
Samuel Baitman stood in a federal courtroom, told the jury he was a kind and loving father, said the government would never prove his intent, and claimed a clean slate. Then the prosecutor picked up a transcript of everything he just said and asked him word by word whether he still meant any of it. He did not. To understand how it came to that, you need to know what the FLDS is. The Fundamentalist Church of Jesus Christ of Latter-day Saints practices plural marriage and demands total obedience to a single prophet. For years, that prophet was Warren Jeffs, now serving a life sentence in Texas for the sexual abuse of a 12 and 15-year-old. When Jeffs went silent from behind bars, he left behind a community of women and children with no framework for what came next. Into that void stepped Samuel Baitman. Baitman had no charisma, no theological standing, and no support from the broader FLDS. Jeffs himself would eventually send a letter distancing the church from him entirely. But a small circle of isolated, conditioned families began listening. Baitman declared himself a prophet, gathered wives, and built the same architecture of control Jeffs had built. Total obedience, suspicion of law enforcement, absolute authority over every woman and child in his orbit. He did all of this while someone was watching. Dr. Christine Marie had entered the community not to expose it, but to help the women inside it. She built trust slowly, without judgment, over several years. As that trust deepened, she began documenting what she saw, not for a camera crew, but for the FBI. She became a formal confidential informant. When Baitman took her to remote mountain locations, she sent a GPS pin to her contact first. When he told her, on camera, that anyone who defies the prophet is worthy of blood atonement, a doctrine that frames murder as mercy, she kept working. The footage she collected became the evidentiary backbone of a federal prosecution that would eventually send Baitman to prison for 50 years on a plea deal. But the current trial is about something else entirely. The charge is child endangerment. The facts are not meaningfully disputed. Baitman was driving a GMC truck through Flagstaff, Arizona, pulling a white cargo trailer, the kind built to move furniture. A passing driver called 911 after seeing small hands pressing through the gaps at the top of the trailer door. Police stopped the vehicle. Inside the trailer were 3 girls, 11, 12, and 14 years old. No seatbelts, no air conditioning. The door unsecured. The interior temperature dangerously hot. A witness testified under oath that a bump in the road could have sent that door flying open, and if it had, they would have lost their lives. That is what this jury is being asked to evaluate. Not 50 years of conduct, just the trailer, the road, the children inside. And Samuel Baitman decided to represent himself. There is a reason the legal world says a man who acts as his own attorney has a fool for a client. Effective advocacy requires emotional distance, strategic discipline, and the ability to see yourself from the outside. Baitman spent years commanding every room he entered. He is not built for restraint. His self-examination before the jury collapsed within 4 questions, 4 objections, 4 sustained. The court didn't need to raise its voice. It simply held firm. And that, it turned out, was more than enough.
Number 1, are you a religious person?
Objection, relevance.
Sustained. Question number 2, do you feel that you were targeted in this case?
I do. Objection, relevance is opinion about that.
Sustained. And the jury is directed to disregard the last answer and the question. Question number 4, why is it that the FLDS, or members of the Fundamentalist Church of Latter-day Saints, seem so secretive?
It's simply said, repeatedly and with increasing precision, no. This is not what trials are for. This is not how this works. And that is when things got interesting.
Objection, character, religion, relevance, pretrial motions and orders.
Sustained. Has there been any change to the witnesses that were in the trailer and vehicle in this incident?
Objection for the question of relevance.
Could you reread the question, Mr. Armstrong? Yes. Has there been any change to the witnesses that were in the trailer and vehicle in this case? Sustained on relevance. Do you meditate before traveling?
Objection, relevance.
Because while Baitman's self-examination had failed almost entirely, he had already delivered an opening statement. An opening statement is not testimony. It is the attorney's preview of what the evidence will show. It is not sworn. It is not subject to cross-examination the way testimony is. But it is a statement of position. It is what you are telling the jury you believe happened. And Baitman's opening statement contained several specific claims.
I ask you to be patient with me since this is my first time I'm not a lawyer. But I'm just saying that I'm a kind and loving father. That's just what I am. I'm very kind and gentle. And I don't ever willingly harm anybody. I don't even spank my children or anything like that. So, also, please realize that the information or indictment is not evidence. I just ask you to make your ruling on facts and evidence, not on feelings or opinions, or whatever stories you've heard. And also remember, as I sit here, that I have a clean slate. Just a very clean slate, so please keep that in mind. And it is up to the state to prove their case. And when the government makes their opening statement,
He said he had been shocked to discover the girls were in the trailer. He said they had begged to get back there.
The girls asked me quite a few times if I could get back there. And I told them no at first, but then I just finally gave in. And it was dumb, I promise. I acknowledge that it was dumb. Shouldn't have done it. And I'd like to mention that I was already in the parking lot parked for probably 4 or 5 minutes before the call service for them. So they didn't have their lights on. And I've had several attorneys, and they told me that is all important, is you have to be pulled over. And I wasn't. I was already parked in the parking lot. Because those girls called me and told me they were back there with their hands out the door. So I was like, oh my goodness, so I pulled over. And some of the testimony you'll hear that I swerved back and forth. Yeah, that's because this guy was following me so close. And I knew that he was part of a city worker. So yeah, I was very paranoid.
He said he had reluctantly given in. He said the situation was dumb. He acknowledged it was dangerous. He said he should not have done it. And then he said he had no intent to harm anyone. The prosecutor had been listening. Cross-examination is the process by which the opposing attorney questions a witness after direct examination is complete. Unlike the gentle questioning of direct examination, where an attorney typically guides a friendly witness through a prepared narrative, cross-examination is adversarial. It is designed to test credibility, expose contradiction, and force a witness to confront the gap between what they said and what the evidence shows.
I want to talk to you about statements you've made about this case, and I want to start with talking about your opening statement. Do you stand by your opening statement?
I probably worded it wrong.
Okay. Do you stand by the claims that you made in your opening statement?
I'm not sure what to say. All I know is I do not want to harm anyone on the face of the whole earth. I don't even like harming animals or bugs. So I don't know why I would harm a person.
Okay, well, I'm going to ask you about some of the statements that you made. And so you said in an opening statement that I shouldn't have done it. Do you agree with that?
I'm not going to agree with it.
You described the situation with the girls being in the trailer as dangerous. Do you agree with that?
Did I say dangerous? I don't remember, but I don't want to, I forget what the word is, I don't want to.
A good cross-examination does not need to be loud. It only needs to be precise. "Do you stand by your opening statement?" the prosecutor asked. "I am probably wrong," Baitman said. "Do you stand by the claims you made in your opening statement?" "I don't know what to say." "You said in your opening statement that you should not have done it. Do you agree with that?" "I am not going to agree with it." "You described what happened as dangerous. Do you agree with that?" "I don't want to get myself in trouble with the law, so I am not going to agree with that." "You described it as dumb. Do you agree?" "Yeah, it was as smart as I could have been." Pause on that last answer for a moment, because that sentence contains everything. He is not denying it was dumb. He is not recanting the word. He is saying it was the smartest thing I was capable of at the time. This is a man who built a system of absolute authority over vulnerable people, who had spent years telling them that what he said was the law, who stood in a courtroom and asked a jury to see him as a gentle father, and when pressed on the most basic question of whether he took responsibility for his own words, his answer was that the dumb thing was the best he could do. The prosecutor was not finished.
You described as what you did was you described what you did as being dumb. Do you agree with that?
Yeah, I did. It wasn't as smart as I could have been, for sure.
You said that the girls begged to be back there.
They did.
And you let them go back there.
Reluctantly, very reluctantly, yeah.
But you gave permission.
I did.
You gave approval.
Not approval. Absolutely not approval. Not one bit of approval. I gave permission.
But those girls were in your care.
You could argue that. They're in their mother's care.
But at the time, you were the adult that was with them, correct?
And so was their mother was right behind us in the vehicles.
Wow.
"You said the girls begged to be back there," the prosecutor said. "Did they?" "They did." "And you gave permission?" "I did." "You said the situation was your fault." "I am not going to agree with that. Their mother was right behind us." There it is, the deflection, the passive reassignment of responsibility to someone else. In this case, to the mothers of the children he had placed in a cargo trailer with no seatbelts, no air conditioning, and a door that was not properly latched, while he drove on 2-lane Arizona highways, and then, when police began following him, accelerated. Consider what was happening inside that trailer in those final minutes before the stop. A witness who was present in the cab testified about it under oath. The door was not fully secured. A girl was on the phone with Baitman, telling him she was holding the door shut. The cab went silent. Then, Baitman sped up. The turn off the freeway was sharp and fast. The witness said it was quite scary for them. And the voice on the phone said, "I don't know if we can keep this door shut." He did not pull over at the first available opportunity. He sped up.
At that point in time, did Sam pull over at the first available opportunity?
No, not to my recollection. That was when we started being followed and he sped up.
Okay, tell us a bit more about that.
He sped up and more police started chasing I don't remember exactly how the events that transpired, but I do remember us in the cab just silent, and then I remember them talking over the phone. I remember coming over the phone and saying the door was getting really hard to hold, and then I remembered coming off the freeway. There was a really sharp turn somewhere there. And he was going significantly fast on that turn, and it was quite scary for them.
Now ask yourself this. If a man genuinely did not know that children were in the back of his trailer, what would he do the moment he found out? And if a man who did know, who had been on the phone with those children the entire trip, made the choice to accelerate when police appeared, what does that tell us about the version of events he presented to the jury? That question is not for this channel to answer. It is for 12 people in a jury box in Flagstaff, Arizona. What we can say is this. A witness who had stood by Samuel Baitman for years, who had believed in him, who had gone to prison herself and then turned her life around, took the stand and testified that Baitman knew exactly who was in that trailer when the trip began in Colorado City.
And I want to focus in on the truck that Sam was driving. Was there a truck that Sam was driving?
Yes, I was.
And what kind of truck was that?
It was a GMC, green, gray, dark color.
Right. And was it pulling anything?
It was pulling a box trailer.
Right. What color was the box trailer?
Box trailer was white.
Was that a trailer that was designed for passengers?
No.
Was it designed to carry cargo?
Yes.
All right. Were there some things in there, though, that were meant to kind of change how it was used? In other words, was there like a bathroom in there?
Yes, sir.
All right. Was there any seating that was put in there?
There was some sofas, like 2 couches back there.
Were those sofas or couches strapped down?
I don't remember. I don't think so.
No problem. And were there seatbelts?
No.
All right. Were there other items in this trailer?
Yes, there was quite a few items in there.
That he knew they were minors. That he knew they were under 18. That they were on the phone with him the entire route. That he was aware the door was unsecured. And that he was in charge of the situation, of the vehicle, of those girls. Every element of his opening statement dismantled.
The service is kind of splotchy between Colorado City and Flagstaff, but every time there was service, then they were in contact.
Okay. And so, was Sam aware that he was in the trailer during this trip?
Yes.
Was he aware he was in the trailer when the trip began in Colorado City?
Yes.
Did he authorize or grant permission for the girls to ride in the trailer?
I'm not sure. I knew that he knew they were back there. I didn't know if they had asked or if he told them to. I didn't know that.
All right. And then in the Flagstaff area, at that point in time, that area, did Sam have awareness of who was in the trailer?
Yes.
Did he know they were minors under 18?
Yes.
In other words, did he know?
Yes.
All right. And how would he have known that?
They were on call with him.
By his own words, and by the words of someone who used to protect him. There is a legal concept worth understanding here called opening statement estoppel. It is not a formal rule in every jurisdiction, but it reflects a practical reality that every experienced trial attorney understands. What you promise the jury in your opening statement, you are expected to deliver. If you tell the jury the evidence will show one thing and it shows the opposite, or if you yourself contradict your own preview under cross-examination, you have not just failed to make your case, you have actively undermined your credibility on every other point you made. You have told the jury, in effect, that your word cannot be trusted. And in a trial, your word is the only currency you have. Baitman made his character the center of his defense. He told the jury he was kind and gentle. He told them he was a loving father. He told them he had a clean slate. He put his own moral identity on trial. And when you do that, when you make character the argument, you open the door to everything the prosecution knows about your character that had been carefully kept out of the proceedings. Baitman is already serving 50 years on a federal plea. The jury in this case was not told that when the trial began. But the moment a defendant testifies to his own good nature, prior conduct that contradicts that claim may become admissible. The prosecution may not have needed it, but the door Baitman opened for himself was not a narrow one.
The women who once followed Samuel Baitman walked into that courtroom and they were unrecognizable. Not in appearance, in bearing. Dr. Christine Marie, who watched this trial from outside the courthouse, described them as strong and articulate, completely different from who they had been inside his world.
How would you describe what we are seeing versus the Samuel Baitman that you got to know over the years?
Oh, he's putting on an act for sure. He's being like really complimentary of law enforcement. You know, I appreciate what you do. Thank you for your service. When in reality, he would use vulgar names for law enforcement and various people. So he's trying to be kind, and he's even asking himself questions because he decided to go on the stand in his own defense. That was interesting.
She said they made him shake in his boots. She said the atmosphere was not tense. It was disbelief. Sometimes even comical. Baitman had announced his intention to cross-examine the witnesses himself, meaning he planned to personally question the girls he had controlled, the young women who had been in that trailer. He was entitled to do so as his own attorney. And then, on the day of the cross-examination, he chose not to. Whether that was a strategic calculation or a recognition that no good could come of it, only Baitman knows. Dr. Marie wore pink to the courthouse. She wore it deliberately.
I've noticed your glasses, your shirt, everything's got sort of this pink theme. I think I'm wearing pink today as well. Why are you wearing pink?
Okay, so Sam didn't like his wives wearing pink, especially bright pink, because it brought them too much attention. So they had to get rid of all of their pink clothes, their pink items in the house. So we want those girls, those survivors, to get attention. So in support of them, I wear pink to all of the Sam Court things. So thank you for wearing pink.
Baitman had forbidden his wives from wearing bright pink because it drew too much attention to them. He wanted them invisible. He wanted them unremarkable. He wanted them to exist only within the frame he had built for them. The women who testified against him showed up to court in their own voices. There is a lesson in this case that has nothing to do with the specific charges, the specific statute, or the specific outcome. It is a lesson about the relationship between control and collapse. Samuel Baitman spent years constructing an environment in which every variable was managed. What people wore, what they believed, who they feared, how they traveled. He was the prophet. He was the law. He was the authority in every room he entered. And then he entered a room where none of that was true. The courtroom does not care about prophets.